this is Bhumika Indulia and welcome to our series Echoes. India today is widely seen as a bright spot in the global economy. The country is attracting global attention, but this growth is not just about numbers. It is also supported by stable policies, strong institutions, and trust in the legal system. As India moves towards the vision of Viksit Bharat, an important question emerges. What role do law, governance, and institutions play in sustaining long-term economic growth? To explore these questions, I'm joined by three distinguished voices who bring perspectives from policy, the legal profession, and corporate leadership. Mr. Arun Chawla, Director General of the Indian Council of Arbitration, Dr. Pinky Anand, Senior Advocate and former Additional Solicitor General of India, and Ms. Manjaree Chowdhary, General Counsel at Maruti. Thank you so much, all of you, for joining us today. So to begin with you, when we speak about India's journey toward Viksit Bharat, what does that vision mean to you?
A very relevant question today. For me, Viksit Bharat is not just about achieving a certain GDP number. It's about building a system where economic growth is supported by strong institutions, stable policy frameworks, and trust in legal processes. Development at this scale requires more than economic expansion. It requires confidence among investors, businesses, and citizens, confidence that policies will be consistent, institutions will function effectively, and disputes will be resolved fairly. So when we talk about Viksit Bharat, we are really talking about an ecosystem where growth, governance, and legal certainty work together to sustain long-term development.
I think Viksit Bharat actually brings back into focus a pre-colonial era. I think we went into colonial era thinking of small things. At that time we were under colonial rule. And I think if you take Annie Besant's, for example, statement towards that entire process, I mean, you think of this whole rise to the top. And I think that is an onward journey as far as India is concerned. And I think it is a motivational factor, I think, which brings into being the fact that we have an entire process of life into being a country which gives to the world something it needs. And definitely time has shown that we've been able to evolve that. Our struggle from the time of being a ruled nation to an underdeveloped nation, yes, to a developed nation, and to one of the most developed nations, that is the dream of all Indians. And I, as an Indian, I think I dream of that I will be there right at the top, which frankly I've already started believing.
You know, just to add to what Pinky has just said, and she's put it very well, that, you know, it's a journey of being under a colonial era, then becoming underdeveloped, then being in a developing phase. For the longest time, at least when I was growing up, we were always developing. Now to come to a point where this is a sense of pride that every Indian feels, that we are now being considered of the top 3-4 economies of the world. We are at a point where the world is looking at us as opposed to we looking at the other side. You know, the things have changed. And it's a feeling of, Hindi mein kehte hain, saksham. To feel a sense of pride, to feel that we are in a stage of being we have arrived in some ways, but we still have a journey to go. And the sense of inspiration and motivation that the people of this nation now feel that, yes, this is something that we can achieve and this is something that we are all working towards. I think that is the kind of feeling and the sentiment that it leaves in them, at least in my mind.
What would you call India now, developing or developed?
I would say in many ways we are developed. We have still a path to cross, and, you know, perhaps we can discuss this later in the podcast. But there are certain other things that we still have to. There's a journey to travel, but I think the process has already started.
Ma'am,
I think there are some clear parameters of development, and I think we fulfilled all of them. I mean, we are a large nation. Our population is one of the largest in the world, and there's no way of beating that. But at the same time, we have the largest youth population. And we have the largest distribution between in terms of gender equality. See the last elections, for example. So as I said, I feel very clearly we are in the developed path by all means. I mean, if you have some difficulties across, That will always happen in any country. You can't fulfill the aspirations in totality of a nation. There is always something which needs to be fulfilled. But develop means you've come to a stage where you're able to guarantee on a large scale across the platform reliefs and survival at the minimum, and better than that. And we have one of the best GDPs. We've had an average GDP which goes across surface. While the world is looking askance at itself, we are self-sufficient. Come what may, India can survive. Come COVID, India can survive. Come war, India can survive. I mean, there are a couple of things that we still need, of course, from everywhere. But that's not the point. The point is, who else can achieve this? Our agriculture, which is considered a problem also at times, in a sense, because agriculture by nature is erratic. But even that itself, self-sufficiency, we can feed ourselves. What else do you need? Roti, kapda, makan.
We can survive the pollution also.
Yes, we have to. We are going through a bad phase, of course. We are dealing with it and we are trying to deal better with it. But what do you do with, for example, like a place like Delhi, which doesn't have air flowing? You can't create air. Even Indians and the greatest nation in the world has its problems. But yes, the other ones, transport, congestions, construction, all those, we are dealing with that. As I said, we are not perfect. Nobody can be. A democracy is never perfect and cannot even achieve that. We are erratic. We are an unruly horse. But that unruly horse is riding well.
Sir, India is often described as a bright spot in the global economy. In your view, what has really set India apart in this moment?
Bhumika, let me emphasize that India's growth story is not accidental. It is structural and policy driven. That is what my recent article in Economic Times speaks about. Even in a volatile global environment, India has maintained growth in the range of around 6.5 to 7%. What has changed over the last decade is that economic policy has moved from short-term firefighting to long-term planning. This growth is supported by several factors: fiscal discipline through annual budgets, institutional reforms, increasing legal certainty, and overall policy stability. Together, these elements have created a framework where businesses and investors are able to take long-term decisions with greater confidence. That is why India today is widely seen as one of the most resilient and promising economies globally.
Thank you, sir. Very insightful. Today's budget seems to do more than announce numbers. They send signals about the direction of reforms. What, according to you, how powerful are these signals in shaping investor confidence?
Again, a very relevant question. Bhumika, budgets today are not just about marginal adjustments in taxation or expenditure. They increasingly reflect the government's long-term economic direction. When investors look at a country, they do not only examine growth numbers, they look for continuity and credibility in policy. And budgets help communicate that continuity. Over the past few years, the shift has been from short-term announcements to signaling broader economic priorities, whether in infrastructure investment, manufacturing incentives, digital expansion, or regulatory reforms. These signals matter because they create business certainty. When companies see consistent policy direction, they are more willing to commit capital, enter long-term contracts, and expand operations. Of course, budgets play an important role in maintaining fiscal discipline, but ultimately, it is the broader legal and structural reforms that drive the larger vision of Viksit Bharat.
Coming back to you, Manjaree, when we talk about policy signals come through budget, how quickly it translates into companies taking some action, and how quickly they translate into their policies?
See, in every country, the budget in India, we can talk about, everybody eagerly looks forward to it because that is your platform where you get to see what's the government policy, what is it going to be on tax, what is it going to be on reforms, what is it going to be on various things that impact businesses in India or the corporate world in India. It's looked forward to very eagerly and also gone through in quite detail. Uh, of course, a lot of it also has to do with is fiscal. So there is a lot of in terms of taxes, etc., where it is less, where it is more, and the CFO and his office gets into a spin to figure that out, and how they will be interpreted. So it's not only just about what it seems. It might seem something very nice when you hear it, but how it gets implemented and what will be the impact therefore. So after about the budget, I think the next 2 months are spent, or at least a month and a half, to see what would be the impact of that on the various things. Now, impacts could be different on different organizations depending on what kind of sectors they are working in. And, whether it's the automobile, manufacturing, telecom, IT, etc., services, everybody looks at it. Then if there are some major changes that take place, so how do you quickly adapt, because you're very quickly getting into your next financial year also after this. So how do you adapt your internal processes? What will be the way of looking at your balance sheet, what has to be plugged in, what doesn't have to be plugged in, what if there is going to be a monetary impact, then the board has to come into picture to understand that, okay, how we balance it out with what has our projections have been. Does it impact your bottom line? Does it impact your future assessments? That is more on the fiscal side, on the tax side. The other could be certain regulatory changes that come in. So it depends again on, some regulatory changes are very widespread and kind of impact everyone. Some are more sectoral in nature. So depending on again what works for you and how it impacts you, you have to do a quick understanding of that quickly and figure out that would there be any risk associated quickly? What kind of enterprise risk? Is it going to become better for us, or is it going to become a little more difficult for us? And if it is better, then what do we do to go? Because every company has a 5-year plan. And then it has a rolling plan. It's quite like the government, right? And how those changes will impact those plans, long term as well as short term, and immediately actions need to be taken. Everybody gets into the groove to do that. Finally, certain changes that come about that ease the doing of business, so you certain decriminalization of certain laws that happen, or changes in the Metrology Act, or changes in the labor reforms that we've seen, or you have new other legislations coming in. How do they impact your ease of doing business? So what kind of things can we do more? Can we ease the burden off? Now, compliance is a given whenever there is a regulatory changes and it impacts you. I mean, it's hygiene. And good organizations treat it as such, that there is no compromise on this. This will have to be done. But sometimes it becomes onerous, and therefore what part is onerous needs to be discussed in the management and in the board to see what measures we can take to overcome that if it is creating certain challenges and this thing. So I think the discussions are very, very robust, and everything is gone into quite detail, and the boards really are buzzing, and the management is buzzing for the next month or two, and you kind of settle in once the new financial year kind of gets into play, because then they start showing their impact and you implement new things around it.
Thank you so much, Manjaree. One question which I'm waiting to ask, but you may choose not to answer it. But while we are talking about budget, I can't resist asking you this question. But there was one reel which came where there was this question which was asked to our finance minister that what is there in the budget for the middle class? And there was a complete pin drop silence. Do you think the budget right now, and while we are talking, this entire podcast is about India's development, growth, do you think the budgets are for the middle class as well?
See, why do we always take it that if there is a change only, or there is everybody thinks, as far as citizens are concerned, across board, The general belief is, what do I get out of it? Only
yes.
when I get something out of it, it is good for me. Otherwise, it's bad for me. Budgets are not meant to be, in that sense, giving benefits. Budgets are supposed to be taking the economy of the country into account and to seeing how to disburse it. So yes, there was no distinct tax advantage to middle level people or middle class, so to say, people. So that, to that extent, you can say whatever you like, but that's a common notion. Budgets are not always supposed to be giving out. We have to see the deficit, we have to see our income, we have to see the GDP. It has to go in accordance with that. So every class expects this. It is legitimate expectation. I am not denying that expectation. I would imagine it so myself if you ask me on a personal front. But having said that, we are a nation. We are not classes of people. So at the end of the day, we have to see the economic growth as a whole, and the budget is only meant to keep all the considerations into balance.
Ma'am, another question to you that we all are looking forward to investor confidence and everything, and they value policy stability, but also consistency in court's judgments. From your experience, do you think it is happening that we have a consistency in our court's judgment, and do you think investors are showing confidence in Indian?
I think we have a lot of steps to take on that direction. I do believe that you're right. I mean, for an investor, what they look for is policy vis-a-vis government,
Yes.
bureaucracy, procedural hurdles, and then lastly, in the event of a dispute, a resolvable position where they can have their results within a time span, within efficient means. A commercial dispute today is of large quantum. I mean, nobody can wait for eons before that issue is resolved. So I think to that level, we do have some issues which are happening at the present point of time. We are trying to take steps towards that direction to ensure, because when an investor takes a risk, he looks at each of these factors. Not one factor. It cannot be only, taking a decision to invest a huge, let's say, hydro project in India, and then not looking at what the consequences might be if there is a downfall, which there always is a possibility of. We lawyers are anyway looking at those kind of situations. If you are certain that that will be resolved either amicably or otherwise within a time span, obviously you will be more inclined to take that decision that, all right, I'll be fine if something happens. If there is any problem of expropriation, if there's any problem of cancellation, if there's any problem of termination, if there's any problem of, let us say, uncertainty, and there has been, for example, unfortunately, now this ex post facto environmental clearance that has undergone the span of ups and downs.
Yeah.
So first it said you can have it, then it said you can't have it,
And now
then it says you are looking at it again. What does an investor do? I can be certain that I have a risk of 10%, let's say, in my project. I undertake that. But that 10% can be 10 to 100. I can't invest at that. I cannot calculate that into my eventuality. So I think it is time that we all look at ourselves, particularly the judicial system and the justice delivery system. Be certain, put down the message clearly for not only investors, even for the country. Don't have ambiguity, because we also have a time factor issue. Let's say that we have an ambiguity on a thought. It takes 5 years to resolve it. Within that 5 year span, what decision can one take? We are waiting for the decision to happen. I mean, for example, in the interplay, the stamp duty, it took the bench forever to come to the conclusion and finally settle the issue that insufficient stamp duty is only irregularity, can be resolved. But it did resolve it, but the time span is there. So in the meantime, your uncertainties become a lot. And particularly in the investor situations, I mean, for a fact also, our BITs, our bilateral investment treaties, I think it is time that we look at them again. We've had a span when we first were totally under the surface, then we started evaluating ourselves and we looked at it again, and then we became more India protective, let's say. We are in the open world today. We are no longer insulated economy as we were pre 1991. So post 91, we have come into era. We are there to compete with everybody. So while we need to protect our interests, we need to protect the investors also. It's a common interest at the end of the day. And in addition, to provide a mechanism that in the event of a dispute, it is resolved not only through national remedies but through international remedies. So I must suggest, Bhumika, here, I'm very strongly in favor of having an international commercial court. As you know, I've recently joined one, but I think this makes a lot of purpose behind it to ensure the confidence of people that, all right, in the event of a dispute, you have a separate regime to take care of this within a given time span and with enough valuation, which is possibly at the national level, national laws, no doubt, but dealt with it in a global way.
Right. Thank you so much, ma'am, for putting this beautifully. Also, you mentioned about the timeline of the judgments. Recently, there was judgment which was reserved for about an year.
I've seen more, Bhumika. You've seen 1 year, I've seen years and years before yet another judge. And that judge, in fact, no more today, but that's another story. And I've seen this through the span of about 5 years. This is post reserving of judgment in the first instance. So, delivery of judgments is one part, which is, of course, you have to give it within a time span for various reasons. I have, for example, argued today before you. You are the judge. You know what I've argued, and she's argued similarly before you on the other side. You know what has been argued, it is there. Also, there's a timeline to a space. It is to be decided within a certain space, and after that, the values also may change. Our entrepreneurial skills and our investments are huge. So, I mean, you are awaiting those outcomes. Let's take the DMRC case, for example. I mean, you find it ultimately being overturned on a curative petition. Now, if the judgment is further held, firstly, there's this whole process which goes right up to Section 34, Section 37, Article 136 in the Supreme Court, and then you have a curative petition, review and curative petition. After that, you have the judgment being reserved. What kind of outcome are you going to have? Interplay of judgments.
So, Manjaree, please tell me, do you think with so much of inconsistencies in our judgments, in the timelines, do you think we have investor confidence?
See, like Pinky alluded to earlier, that investor confidence is not only dependent on timely judgments. I mean, there are many factors that build investor confidence. Certainly the GDP, certainly India is not an emerged economy, I suppose, not only emerging. Ease of doing business, new reforms, regulatory, lot of regulations, new reforms, and some sense of political stability, which we've seen. That gives a person coming from outside a huge amount of confidence that if it's the same government running, you will find a consistency. You will find regulatory stability that will continue. And the sentiment that is, of course, the GDP and what is. Now, when you invest, obviously you're going to set up something, you will have third parties that you're interacting with. There are going to be bound to be disputes and commercial disputes or otherwise. Everybody looks to speedy closure of that, the outcomes, because it helps you to take decisions. It helps you, it can stall a project, because if it is sub judice, something stops and you're waiting for the outcome. It has far-reaching consequences on other decisions that you might have to take, which are related to the larger business that you're looking at. Certainly, it forms one important aspect of investor confidence. So therefore, I think, and Pinky was speaking about it earlier, that this is an area that we could do much better on. But it's also something that we have to understand that we are a very large nation and a huge population. Look at the number of cases that are at in pendency, both at the Supreme Court, High Court, other tribunals, subordinate platforms or authorities that are looking at them. Though the government is doing its best to bifurcate and get commercial disputes in one place, you have the NCLAT, you have other areas, the insolvency, bankruptcy, platforms, etc. Those are wonderful things. But is the outcome happening at the speed with which we are looking at investing in India? Perhaps not. And that always will remain a little bit of a blip. And we look forward to times when this can happen faster.
And while we are talking, yes, ma'am.
I just wanted to add one thing to what she said, and she's very right. I mean, this is one of the factors. There's so many factors of investment. But having said that, certainty is not only in timely decisions and the fact that it should be given within a time space. What we do have a divergence with at times now is that we have every court believing it's the only court and giving a judgment which renders itself. And so there is lack of certainty as to what the right position is. And therefore, decisions are taken either even by government, which government in any case is taking decisions based on strategy and policy and whatever is there in law. So let's say A High Court, for example, holds one view, B High Court holds a different view, and C holds A's view. What does a government do? A. And B, ultimately, when you have positions where even within the Supreme Court, for example, you have different judges deciding differently, and within different tenures, let's say, even decisions overturning and yet again overturning. At the end of the day, I think we need to pay a little more attention to that certainty. We need to ensure that there is one thread that goes across, whichever way it is, First, even that is acceptable or not, maybe another matter. But at least let's have a line. Certainty is the key to success. Certainty is the key to the rule of law. Certainty is the key to risk taking. I mean, each of these factors prevails amongst that.
Right.
She said it so well, and I was just thinking that when you invest, and if you're a large company, you perhaps are invested pan India. So, in one particular state, you get an X judgment, and in some other state on the same matter, you get another judgment, and there is no connect, and that pushes you. You're at loggerheads to say that I'm doing one thing here. How do I react to that? And the same thing here is giving me another judgment, and it can leave the business people in a real set of quandary. They really don't understand how to manage this, and then that whole thing about can we get this better and can this be done better is something that always comes up. So while the larger sentiment is great, but this aspect can be better, certainly.
Moving forward to my another question, we often talk about physical infrastructure driving growth. Would you agree that strong legal system like enforceable contracts and predictable outcomes are also form of a economic infrastructure?
Absolutely, no doubt. In fact, I would go a step further and say that enforceable contracts are foundational economic infrastructure. Physical infrastructure such as highways, ports, digital networks, they reduce the cost of moving goods and services, but predictable legal outcomes reduce the risk of moving capital. So as economies expand, especially in areas like infrastructure development, manufacturing, and cross-border trade, the number and complexity of contracts naturally increase. So disputes become inevitable. What distinguishes a mature economy is not the absence of disputes, but the certainty and efficiency with which those disputes are resolved. If contract enforcement is predictable, capital flows with confidence, and long-term investments deepen. If enforcement is uncertain or delayed, risk premiums increase and investor appetite weakens. So an economy aspiring to become the world's third largest cannot rely only on physical expansion. It must strengthen its legal architecture as well. In that sense, enforceable contracts are the invisible scaffolding of development.
Sir, a follow-up question on this that please tell me, what is the role of ICA in India's development or India's growth? How is ICA and what is ICA doing different?
See, as I've said earlier in my answer to you, that dispute resolution plays a very important role in the economic development. It arouses confidence amongst investors that in case of any hiccup in their contracts, there is a system, which is an alternate dispute resolution system like arbitration, which will come to their help in resolving the dispute easily and smoothly. And that is where ICA steps in. ICA has earned the reputation of being a premier organization in the country. In fact, it has earned a lot of respect among international investors, international platforms, and we are particularly well known in jurisdictions like London, Hong Kong, Singapore, that the institution like ICA is one which can really help in resolving commercial disputes.
Sir, thank you so much. Manjaree, we have been talking about policy stability and at the macro level, but inside boardrooms, do companies actually feel this predictability when making long-term decisions?
Yes, to a degree. I would agree because, when you talk of the factors, stability in today's environment, when you look at Viksit Bharat, one of the important stabilities is political stability also. If you have change of governments, very quick change of governments, then there is always a tendency to redo laws, relook at reforms, change the way of doing things, priority change. And therefore, that leaves business people in a huge sense of uncertainty. So, political stability certainly provides a sense of comfort that yes, some things are going to be, same, and therefore the sentiment of long-term investments and then reforms, stability on reforms. I mean, we do have various reforms coming, and those also tend to build investor confidence. They also tend to give boards a direction on certain areas of business that they wish to get into, what kind of regulatory changes are happen to be in the offing or are coming or have come. It brings about a sense of a direction to the board. And when you are investing in businesses and when you're expanding and growing and taking very strategic business decisions, and in a longer time frame, say from there would be certain small changes or short term changes, and then there would be things that the businesses look at on a 5-year at least term. So all these things can go to contribute to bringing that confidence that yes, it is good to invest, it is good to take this forward. Otherwise, if you don't have stability of reforms or stability of the government, then everything is up in the air, and you really don't know that you might want to invest in one direction. And what happens if there is a change and suddenly the government changes and everything goes, and the whole sentiment, sort of the business scenario, gets upset. And lastly, also, in terms of institutional strength, India has come up with various types of institutions, and these support bringing about better clarity of your reforms, or how we are going to be implementing them, enforcing them, and giving a sense of comfort to the board members that yes, there are platforms for resolution, there are platforms that can happen. That's another matter, that the resolutions may take a longer period of time, but there is certainly an infrastructure that has been put in place, and that I think India in the last decade or so really has gone far ahead and built that up, and that certainly has brought about a sense of confidence in the boardrooms.
Right. Thank you so much for explaining this so beautifully, Manjaree. Ma'am, coming to you, even when policies are clear, disputes often arise in how they are interpreted or implemented. In those moments, how critical is the role of courts?
Is the moment, because in our constitution and our way of democracy and the way we run the country, ultimately you have different legs. You have the executive, you have the legislature, you have the judiciary, and judiciary is the third largest pillar. And of course, I shouldn't ignore fourth being the media. I must highlight the fourth estate, as we call it. But having said that, the third pillar really is the bulwark of life, because the executive takes a call, law is made by the legislature, but the interpretation of that policy or the law is by the courts. So I think the roles of the courts as arbiter in this entire scenario is very important. I mean, to what extent courts literally consider that government policies are built with regularity, reliability, credibility, power. I mean, all those factors. And in fact, increasingly, I think if you see the need of the hour also is for a kind of collaborative approach between the government and the courts, to the extent that for investor confidence, and I speak locally and internationally, I never speak internationally alone. For all that, you need to have that clarity that not only will there be a policy or a rule or a law, but also it will be implemented with the same kind of certainty, so that it stands for that. And I can take my risk. Economists, investors, entrepreneurs take risks built on percentages, built on what is the capacity, what is the entitlement of risk, what is the proportion of risk, and they are open to take it. They are not risk averse. Yes, they are, but not uncertain. So the uncertainty is what sells. So I think we need to, and we have that into place. This much we have into place, that we have an entire conception of the country and the policy laid down by the surface. And I think to that extent, the courts are very, very cognizant of the fact that India is standing as a developed nation and sending this message across. As she rightly said, political stability also. Right. It is so important, the fact that you will have a regime. Secondly, that regime with a certainty of thought. Thirdly, the declaration by that regime of that certainty in principle, which is by way of, let's say, rules. Let's say Commercial Courts Act, for example. You got the Commercial Courts Act only for this. We evolved arbitration into such a big regime by this thought. And the latest is one of the most imperative steps that we've taken, with the backlog, etc., what has been happening, and the way investor confidence also has to be built. We've taken into account mediation as a major tool. Now, in fact, today earlier I was hearing somebody say that, in commercial litigation or commercial disputes, mediation is not the way out. It is. Everywhere in the world, we are doing it. A commercial person or a commercial investor, in fact, looks at early resolution. Any money in the pocket is better than no money in the pocket, and all money outside it. So, I mean, when you talk about mediation, I think we started in a smaller way with mediation in our various ways. And of course, our ancient country, I'm not talking about that, I'm talking about current day. But the 2023 Act that has been brought and the Prime Minister's initiative to make mediation a complete goal by itself. So we've had two major national conferences, as you know, one in Delhi and then second in Orissa, and the third is in the offing in the near future. The whole message is down that we have backlogs, we have time delays. That aside, to build it into a time situation where disputes are resolved so that everybody goes home happy. And by the way, again, Bhumika, I've been seeing the centers work in various parts, the Supreme Court aside, High Court, district courts. It is flourishing with action. And the disputes may be of whatever kind, incidentally. The point is they are being resolved and people are going back happy. Any resolution is better than any fight.
Ma'am, considering you have worked so much in arbitration, tell me something. There is a saying that this is doing the rounds right now, that litigation and arbitration are now almost the same. The kind of timelines, now arbitration is no different.
It is actually worse. Arbitration is actually worse, and let's face it, because you have one extra tier. In litigation, you have, let's say, 3 tiers, right up to the Supreme Court, starting from the trial court to the appellate court, and then finally the Supreme Court at the least. In arbitration, you have the arbitrator's award at the first instance, and then you have section 34, then you have section 37, and then you have article 136. So you have 4. That's a clear run. It's clear mathematics. It's nothing else. The difficulty, in fact, that is one of the reasons that we are all grappling with the fact that we need to cut down and circuit this process. Because what's happening is this extended length of time. Then people say, why not take the option of 3 and why of 4? And the time span over this, the arbitrations, for example, I'm sorry to say, because one hates saying it, you're actually actively practicing trying to resolve disputes, and arbitration was the way out. But you're taking almost 5-6 years in the arbitration process as compared to a commercial suit, which could take lesser. I mean, there is an unfortunate part to this paradigm, and we have to cut short. We have come across some bills now, they are in the offing. So there is a discussion of forming an arbitral tribunal. I personally have proposed, at least, let us do away with one tier of litigation. So make 34 a composite appeal, a full appeal, make it a full appeal, and be done with that. Hopefully then 136 is somewhat more limited in comparison. Take out 37. These are some of the proposals that have to be brought into being. People want a time frame. Nobody's got the rest of the time in life to wait for a resolution.
Also in India, we have a litigating mindset. So they will find 100 ways.
Our people to litigate.
Our fallacy and our advantage is in both. One, we love and we respect the justice delivery system. Everybody has full faith in the justice delivery system. So much faith that you will go right up to the Supreme Court and say, "Mujhe kuch to chance hai, mujhe kuch to mil jayega, nyay mil jayega." And that is for the common man across the surface till date. So therefore, some advantages also turn out to be disadvantages. So everybody will go. Obviously, that increases the time limits within which things will happen.
If I might just add on this point, looking at it more from a corporate standpoint, nobody wants to get into protracted litigation. And this mediation thing is now come, and we are still, some parts of it has to be implemented further, etc. But the sentiment on mediation has picked up in the last 2-3 years. However, even before that, you see, when you write international clauses, there was always something that, if there is a dispute, the two parties will sit together and think about it, or at least the two CEOs will go and have a discussion. If that fails, then you get into arbitration, or if there is a judicial process that you are going to follow. I have noticed that smart organizations do everything possible to mediate. There will be disputes. And I'm not with the government really, because with the government, it's always a certain set process. I'm talking of between two third parties, two separate private parties. And I have been privy to settlements which have been finished in about a year or year and a half, and you have secured most of your monies, you've let go of some, but believe me, had you gone into an arbitration, which could have been an international arbitration, you would have probably spent 10 times more only on travel and only on, the lawyers' fees, etc., and outcomes would probably have been same or not even same.
I still have my doubts with mediation. I think we are still in the trial phase, and probably after a few years, we'll again come back to arbitration.
No, you're right. I agree with you, Bhumika. We may not come back squarely to arbitration, but this mixture that we've been having, the hybrid of arbitration, mediation, litigation, somewhere down the line will be taken from each step. But arbitration will be there. It has to be there. There's a reason. Mediation is built upon parties' consent. Litigation is built upon adjudication. Arbitration is built upon a third party deciding, almost adjudicating or arbitrating, let's put it another way, the disputes between the parties. So there's a different nature which is required in each of these processes. You can't really superimpose, because if everybody would mediate, of course, yeah, I mean, you have the panchayat and everybody sits and everybody goes home happy. But it just can't always work out like that. So you have to have all models and have them efficient within time-bound processes and have a hybrid. So I found a number of cases where arbitration litigation or arbitration mediation have worked very efficiently, where the end result has been a net result. But the main advantage of mediation is it is a full stop. There's no further law process that comes into being which tilts the balance, aside from the fact that some give and take, as she said, really concludes the disputes between the parties. In any case, somebody wins and somebody loses. In this way, everybody wins out in a full way.
Thank you so much. Thank you, Manjaree. My next question, again, coming back to our main point about the arbitration. So, arbitration is seen as a key solution for the commercial disputes. What changes do you think in the legal system could make dispute resolution faster and effective?
Are you talking about arbitration or are you talking about the litigation? In arbitration, actually, I made some of the suggestions which I had in mind. There are a couple more that are very important. So I'll tell you what. Today, arbitration is still ad hoc, as a matter of course. I mean, even though we have great institutions which are taking care of it, but institutional arbitration is still minimal. Ad hoc arbitration is far more. So you do need to institutionalize arbitration into structures, because there is far more accountability. Secondly, we have no system of audit of the process or of arbitrators. Now, we all are very wary about all this accountability, but I do think we need some kind of audit, some kind of ranking, some kind of accountability and transparency in arbitration, so that people do not lose out on the ground. I mean, for example, you'll have some finding that the arbitration is biased, or you'll have a finding that the arbitration... Also, see another feature. For example, there are some arbitrators who have number of hundreds of arbitrations going on simultaneously, don't have the time. You have a wide pool of arbitrators who have none. So, I mean, you do need to have efficiency in terms of time. It can't be class ridden into one direction. It has to go a larger surface. We don't have any accounting of the awards. I'll give you an example of ICC, for example. The ICC itself has a scrutiny post-award within the system. It is not merit-based, but it is general-based to see that it fulfills the requirements of everything that is concerned, so that you don't lead it for another trial stage later on the ground of error or something which is patently wrong. So a lot of what our courts do are done at an earlier level, so that it doesn't lead to further litigation. You also have the question of, for example, deciding the arbitrator's bias by an independent body, so that should be done again at a first stage. Next, I do have a suggestion, and I have already made it good, that have a full-blown appeal, have a permanent court of arbitration, as we've tried in the commercial courts, but I'm afraid it's not of such success. You have a permanent court only for arbitration, and you have it at one stage and you are done with the appeals. We do away with 2 tiers of appeals. Once we have accountability, now we have timelines, for example. They're doing very well. The timelines have been put in very well, and then indeed they're working very well. But if you have one court of appeal on a permanent basis, which is doing a full-blown appeal rather than any kind of limitations, go for it. No problem. Have a separate regime for international. We cannot afford to have the same notions across. There has been a time when as I said, we are national. But when we deal internationally, we have to have some modicum of response for the global practices, and we can't only take it at our levels alone with whatever we need to do. And as I said, finally, we have to, ultimately, we put this process into being. we will have something which will work efficiently into process, because the lengthiness of the system, the 4th year, is what is destroying arbitration the most, and the lack of actual accountability and auditing that we have. We are not accrediting arbitrators. We should accredit the arbitrators, give them some ranking, whether by numbers, by merit, whatever we think best. But when judges are appointed, they are given, I mean, they are appointed on based on some activity. Now you have senior advocates also, for example. You have some criteria, and if they don't meet it, well, then don't at least give them cases, if nothing more than that. Either blacklist them if you like, if you don't. I mean, why can't we be open to criticism of ourselves? We are supposed to perform. If you don't perform, well, we should be open for that.
This is one of the amazing, fantastic suggestion. On that point also, whenever we go to London International Disputes Week, and there is one session especially on our judgments, there is some criticism on our judgments also, which is there. Also, are the suggestions which you have mentioned, I don't think they have been incorporated in the Amendment Act.
Not all. Some of them, one or two do appear. A lot of them, you're right. A lot of them are not. In fact, I have made them on an independent level, and I will continue to advocate them, because I think this is important. If there's any tweaking of that, that's another matter. But this will lend to the efficiency of the system, definitely. And I think we have to grow up as an economy. Even on the rule of law side, we have to find ourselves open to, as I said, amenability to accountability to what we do, how we do, when we do. If we don't, like time limit, we've set in statute. And we are not going to do anything till we are made to do, all said and done. Human beings are like that. So you have to lay down institutional norms, structural norms. It has to come within those parameters. Otherwise, we'll continue to do whatever we want to do. I will do what I want to do. For example, Manjaree will do what she wants to do if she's an arbitrator. Let's put it like this. So we can't have that discretion. We are not God unto ourselves.
Absolutely. I think I would love to have a piece from you on the suggestions which you have given.
I would definitely forward you.
To because these are some of the fantastic suggestions. I think a lot of criticism which comes in arbitration, all these suggestions, you have targeted all these issues. So thank you so much, ma'am, for explaining this so beautifully. Manjaree, coming back to you, we have been talking about data privacy, and before this also we had a conversation about data privacy. How is Maruti handling with the data protection requirements and the compliance requirements?
See, this is an act which was long awaited and finally did come, and has taken forever to finally get, the implementation of that. And that also now in phases. So I think we've had a very proactive approach towards this act, because we do believe that it has far-reaching impact on the organization and kind of touches everything, especially larger organizations such as ours, because of the size and scale and just the sheer numbers that we have. Therefore, we have been doing work, and I've been personally involved in it along with our digital and IT teams, to study, to understand, and then put to what is going to be the new provisions and the requirements under the new act. And of course, we waited for the rules, so those have also now come, and put in a framework in place for the organization. You really have to put a framework, because we are not a small organization. We really got to put a structure around it. Otherwise, it's not going to work. And the penalties are huge, as you know, per incident. So from a board standpoint, this is a high risk area. And therefore, we need to do whatever we can to make sure that it is properly studied, properly, the structures are in place, and the mitigation strategies are there. So we are into it for about a year and a half now. We should be nearing completion in another 6 to 8 months. We've built policies. There's one part of it is the legal part. The other is the techno-legal, where you got to, tweak your systems, your IT systems, your whole, it's a systemic thing. So make sure where your data is coming from. So we've kind of looked at the various touch points, in which go close to about 600 to 800 touch points where we get data in from others, study that data, create policies around it, privacy frameworks around policies on that as to how we are going to be managing that data. Then, of course, it's the whole thing about consent management. That is the biggest part of this act. Not only consent management going forward, but consent management of legacy data that you have of people within the organization. No, it's not. No, law is silent. We were hoping that in the rules they give us some time frame within which we got to go back and then manage it. but they've kind of kept quiet, which also then leaves it to us to create reasonable, kind of guardrails around that. So I think, personally, I feel earlier we were all contemplating 3 to 4 years or 2 years or 3 years that you go back. We are also hearing a lot more in the industry that you go back to the time the data was digitized. Since then, because then you do have some records of that, and then you can go and approach people. I think we will evolve with some sort of approach on that, and what we will go ahead and do. Besides that, I also feel this whole you got to get your grievance redressal mechanisms in place very well, which is an important part of this framework, because there is a certain time period provided, which is a very short window, when somebody raises a grievance and your data protection officer is unable to give adequate response to the person who's raised the grievance. The person has a right to straight go to the data protection board. So it's like, the regulator comes into it very, very quickly. So you, as an organization, to ensure that it remains and is contained within the organization appropriately, really needs to make sure that that is in place. And the last of it is these data managers, content managers, the new concept of content managers, which I feel is currently interpreted as a data principal. They are going to support data principles, because data principles, an average man really doesn't know what is privacy, and how his data becomes private, and how that data is, if it is digitized, and managing it. So they are going to support them. Now, for organizations, it becomes a real task, because you have like 30,000 employees. Now, how many managers are going to be managing them, and how many people are we going to interface with? How many content managers are we going to interface with to be able to resolve issues? So I think that, to my mind, is one very critical area. We thought that they should have allowed for data managers to also be available to the organizations, so that we can use one or two of them and interface with the rest of the employees or whoever's data that we carry.
Also, I feel we are not educated enough about the privacy laws.
Privacy is a recent phenomenon,
Very
Bhumika.
recent.
So therefore, you must understand it is something that has come around after Puttaswamy and
Yes.
basically been made a rule of law, and something which has come around after that, the entire Aadhaar, it went a big way. So we are grappling with something new, and the balances, whenever you develop something new, even the rights flowing from that and how they are to be construed, constructed, there's a lethargy, there is some lacuna. These things will always come around, aside from the fact that privacy is a very questionable thing at times. I mean, what is privacy, and to what
Yes.
extent privacy should go,
Yes.
to what extent it will override other rights?
Yes.
Believe me, it's a big question. I mean, I, for example, will just tell you offhand. I mean, privacy, security. We all know which one should ride first, but people will still try and cite privacy. Privacy and health. And health as in emergency health. Let me put it another way.
Yes.
I mean, there are questions which are writ large. And I do think, I mean, though important, by the way, I know privacy is so important for the current generation. So my statements may be misconstrued also. But at the same time, we have grown up with not such an exclusive sense of privacy whatsoever.
Correct.
Secondly, public life, when you enter into a kind of public life, anyway, privacy is diluted,
Yes.
which is also another phenomenon that one must appreciate, because you've lent yourself open for public life. If you really want privacy and you want to be a hermit and a recluse, then maybe you should choose elsewhere. So anyway, these are just some of the thoughts. I am not taking a final call on them, but giving you some of my personal thoughts on it. You know that when you're even doing Google searches, you'll find that you'll be getting some calls randomly.
Yeah,
It's very
yeah,
obvious. The third
absolutely.
party situation is very apparent. I'm saying those are different concerns, and they are legitimate concerns, but at the same time, I was just saying that you have to construe that within some kind of boundaries also.
When people like me who understand privacy laws, when we say it, it's not impactful. They are like, we are somewhere lacking in giving the information, or we are. What is ICA doing in 2026?
Well, as a matter of principle, I do not show my cards.
Any upcoming event?
But I will definitely like to share the immediate event which is coming up on April 10th and 11th. It's an international conference where we have invited many foreign speakers and to share best practices, and which is focusing on legal technology, economic development, and cross-border disputes. The conference is being inaugurated by the Chief Justice of India, and of course we have the valedictory by the Honorable Union Law Minister of Law and Justice, Shri Meghwal. We have other legal luminaries in the conference, and we will also have foreign experts and many delegations to be part of the conference.
That's amazing, because 2-day conference ICA is organizing, and we are hoping many different countries will be participating in this. One of the biggest, I think, ICA conference which ICA is organizing or has organized so far, which I'm presuming. So wish you all the best for the conference.
Thank you very much.
Okay, my last question. Looking ahead, what one change, whether in policy, law, or institution, that will shape India's journey towards Viksit Bharat?
Bhumika, if I had to highlight one area, it would be strengthening dispute resolution systems, particularly institutional arbitration. As India's economy grows, commercial relationships become more complex and disputes inevitably arise. The key issue is not whether disputes occur, but whether they're resolved efficiently and predictably. So institutional arbitration plays a critical role here. It offers structured procedures, technical expertise, neutrality, confidentiality, and international enforceability. In a rapidly expanding economy, unresolved disputes often lock up significant capital. So efficient dispute resolution releases that capital back into the economy, restores commercial certainty, and strengthens investor confidence. So if India is to become the world's third largest economy, dispute resolution cannot remain a peripheral issue. It has to function as a core economic infrastructure. So ultimately, sustained growth is built not just on policy or investment. It is built on trust. And trust depends on the credibility of institutions.
I would probably say that India has one of the best regulations that any nation probably could look at. I think we do a fantastic job on that, and we continue to do that. What I would like to see in the next 1 decade, which is really going to add to Viksit Bharat and build confidence in the corporate India, also anyone who invests here, is about the implementation of those laws, how we enforce them. Because again, that also has a link to what gets into a dispute. Oftentimes, we have to go into courts or we have to arbitrate on things which actually could have gotten resolved at an enforcement level itself. So a little bit more understanding that laws are just not to be made, they have to be implemented. And the authorities who are responsible for doing that should, step forward and ensure that there is a sense of better enforcement, which will also reduce disputes, I feel, and would reduce the burden on courts. And that can go a long way to giving us a very bright Viksit Bharat.
Right. Thank you so much. Ma'am, what?
I think for a Viksit Bharat, aside from my dreams for the citizens of this country and the youth of this country, which is the predominant force, all said and done, I think there are several concerns and disputes which are needed to be addressed. So one of the ones only I will mark out is the priority to be given to commercial disputes. So far, we've done certain prioritization on human right concerns. For example, women, for example, children, for example, crimes, and they will remain paramount. There's no issue about that score. However, commercial disputes and the legitimacy to be given to that process is something that is necessary. So even today we will talk about it. For example, in Dubai, a check bounces, you can go to the police after notice. If there's that the check is not returned, you are inside jail. There's no discussion. Here we have a process where even 138 Negotiable Instruments Act hangs on forever. So therefore, years, 4 years, 5 years, and those kind of processes. So therefore, you need to put a time limit not only on the fact that there is a law. There are several laws where you have. The process itself has to be fine-tuned. Our decision to go with due process is well justified. But in certain areas, expediency is called for, which must override. I've issued a check. I mean, come on, at this end of it, I am required to honor it. I can't keep finding ways and devices. Gone are the days when bank documents were filed and people used to say, oh, sorry, I signed a blank document. I didn't see there were blanks in the document. And that defense went on for 15 years. And I think courts came down very heavily, not in the initial stages, but about 10 years down the line, courts came down and said, sorry, you signed a document. You should know what you are signing. But for a long time, some blanks which were standardly even left in bank documents were accepted as a ground to do away documents. We do need to have commercial expediency built into the whole situation.
Thank you so much, all of you, for giving me your time. It was wonderful talking to you.